The Supreme Court decision, which was handed down in the case of Stoffell Co and Grondona on the 30th of October 2020, is concerned with a very interesting point. Should the law help a claimant who has conducted a fraudulent act? The facts of the case were as follows. The claimant, Ms Grondona, had instructed Stoffell Co to represent her in her purchase of a property. The solicitors admitted that they had conducted their work negligently because they failed to register key documents with the land registry. This meant that Ms Grondona was not registered as the legal owner. Ms Grondona had purchased a property with a mortgage, and the missing papers meant that, when Ms Grondona fell into arrears, the bank could not enforce its security. The bank then got a money judgment against Ms Grondona. Ms Grondona brought a claim for damages against her solicitors, arguing that, had the solicitors not acted negligently, the bank would have taken possession of the property, would have sold it, and the debt would have been satisfied in full. As stated, it was not disputed that the solicitors had been negligent, but the solicitors argued that Ms Grondona was not entitled to recover damages against them because she had obtained the mortgage fraudulently. You see, Ms Grondona was not the true purchaser of the property, and she had misrepresented the position to the bank to help her business associate, Mr Mitchell. Without Ms Grondona's help, Mr Mitchell was unable to raise funds because of his poor credit history. The solicitors were not aware of the fraud at the time. The solicitors therefore rejected the claim on the basis that it was tainted by illegality. The judge at the trial rejected the solicitor's defence because Ms Grondona did not have to rely upon the illegality to prove her claim. The solicitors weren't happy, and they appealed the judgment. In the Court of Appeal, it was accepted that the reliance test had been overruled by the judgment in Patel and Mirza, a 2016 case. The case of Patel had introduced a trio of necessary considerations. The first consideration is to look at the illegal conduct and to see whether the purpose behind it will be enhanced by denying the claim. The second consideration is to look at any other relevant point of public policy which the denial of the claim might impact. And the third consideration is to look at whether denying the claim would be a proportionate response. Applying the Patel test, the Court of Appeal still held that Ms Grondona was entitled to damages, pointing out, amongst other things, that whilst the mortgage fraud was a canker on society, it was not in the public interest for solicitors to escape liability for their negligence. It was also noted that Ms Grondona's illegal conduct was not central to the dispute and it was part of the backstory. The solicitors advanced matters further to the Supreme Court, and the trio of considerations in Patel were looked at again. The Supreme Court held that it was correct that the law should condemn mortgage fraud as a matter of public policy, but allowing the civil remedy of damages for solicitors' negligence was unlikely to undermine that policy in this case. It was also noted that the failure to register the transaction happened after the fraud, and that it was also in the bank's interest for the property to have been registered at the land registry. I do have some sympathy for the solicitors. I understand why they were keen to challenge a finding of negligence made against them by a client who had been involved in a related fraud. However, if you consider the facts of the case and apply it against the trio of considerations in the Patel case, it is clear to see why the court did not dismiss Ms Grondona's claim. Do you think that the solicitors ought to have been ordered to pay damages to Ms Grondona? I'd be interested to hear your views.